I'm Ken Carlson. I've been an attorney helping tenants since 1980. I'm a graduate of UC Berkeley and Loyola Law School. I operate the caltenantlaw.com website, where you'll find this and other videos, as well as lawyers to help you. I'm not in it for the money. I enjoy empowering you. Legally, when you rent a place, you buy the exclusive right to possession. The landlord still owns title to the property, and he has the ability to use it as security for a loan and other rights. This is one of those possession is 9/10 of the law things. You own what is technically called a leasehold estate until such time as you leave the property, voluntarily or forcibly by the sheriff. You control who can come into your rented home or business, or onto the property if it includes open land like a yard. As between you and the landlord, you have the superior right over who can come into your place. As the tenant, even during an eviction lawsuit, you can legally prevent the landlord from coming in and prevent anyone else who claims that the landlord gave them permission to come in. We have nosy resident managers who think that because they're entrusted with the keys to all the units, they can go in any time they want. It doesn't matter what the landlord told them. You are the one whose permission they have to get. Even if your lease says that the landlord can come in at any time, that part of the lease itself is illegal and has no effect. Even if you're wrong in refusing their entry, you still have the right to control it, and the landlord has to resolve that dispute in court. You have what Civil Code 1927 calls the right to quiet enjoyment of the property you rent. Trespass is a violation of the right to possession, not to title or ownership of the property itself. Since you own the right to possession, you can have the police arrest and criminally charge anyone who you tell to get off the property who refuses to do so, including real estate agents, property managers, workmen, and other agents of the landlord. Unfortunately, you can't criminally charge the owner for trespass, but you can sue him and anyone else who trespasses onto your property. If the landlord refuses to comply, you call the police or sheriff, and they will side with you. Landlords hate being told by the cops that they can't come inside their own property. Your right to possession, and that level of control, is subject to one exception in Civil Code 1954. It says that except for your permission or an emergency like a fire, the landlord cannot come in unless they have a permitted reason, give you a written notice stating that reason at least a reasonable time in advance, like a day, identify the date and approximate time that they'll come, and only enter during normal business hours. Also, the landlord cannot abuse that right. If the lease gives the landlord more authority than that, that part of the lease is illegal under Civil Code 1953, and no such authority exists. The reasons are, in the exact words of the law, to make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary or agreed services, or exhibit the dwelling to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make the security deposit inspection before you move out. That does not include snooping around, an annual inspection, checking the smoke detectors, taking photos of the interior to post online to sell the property, or making alterations like rebuilding the kitchen. In that regard, some landlords try to evict you by making your home uninhabitable for months under the guise of making repairs. If they're going to do work, you need to ask exactly what they're doing. Do they have permits? Are the workmen licensed contractors, and how long it will take? If the landlord won't say, suspect the worst and stop it. You have to get written notice, like on paper, not a text or email or phone call. That's because of what the notice has to say and how it has to be given to you. If it's mailed, it has to be at least 6 days before the date of entry to allow for the actual mail service. The notice has to identify a permitted reason for entry. Landlords often use a form with checkboxes for things like an annual inspection or checking the smoke detectors to make it seem legal to do that. The date of entry and approximate time of entry must be provided. That doesn't mean a span of every day for a week or some time between 8 a.m. and 6 p.m., unless the type of work will actually take that long inside your home. Showing property might be 5 to 10 minutes. A plumbing repair might be a few hours. Normal business hours are not specifically defined, but are commonly understood to be 8 a.m. to 5 p.m. or normal weekdays that are not holidays. An exception exists for real estate agents who can show the property on weekends, which are their main workdays. That exception does not apply to normal workmen. Another exception exists for real estate agents as to the written notice requirement. If you get a written notice or letter that says, over the next 120 days, the property will be shown by real estate agents, they can call you 24 hours in advance instead of giving you a separate written notice each time, and leave their business card to show that they were there. Real estate agents must accompany the prospective buyers inside your house. Real estate companies commonly use what is called a lockbox, which is a mini safe that might be attached outside your door. It uses a special key or combination, but the key to your front door is inside it. This is for the agent's convenience to get in, but it does not excuse failing to give you notice in advance or any of the other requirements. If anything is broken or missing in your home, the agent and the landlord are responsible because they let the buyers in. Realize that the supposed buyers could actually be thieves casing your home for a future burglary if they don't steal whatever they can while the agent is showing them the house. The same concern exists with real estate agents taking pictures of your personal property inside your home to post on the Internet multiple listing service for the public, including burglars, to enjoy. The right of entry under Civil Code 1954 cannot be abused. There's no definition of that, but it stands to reason that the purpose of the law was to minimize intrusion of your quiet enjoyment, exclusive possession, and privacy. Landlords may try to have an open house where they tell you that you have to clean up your house and be gone for that weekend, but that is an abuse. Landlords may plan to fumigate the house for termites in preparation for a sale and tell you that you need to be gone for 3 to 5 days and package up your food, but that's an abuse. Similarly, the landlord may claim that they need to make major repairs like mold removal requiring you to be gone for weeks, but that is an abuse. Also, the landlord may have so many buyer inspections that it becomes a nuisance and an unreasonable interference with your quiet enjoyment. A lot of conflicts arise over these types of situations, but the solution is to negotiate a fair deal where the landlord gets what they want and you get fair compensation. Here, the real estate listing broker can get that done. He wants his commission, and the landlord listens to him. You can have a temporary relocation agreement with a set ending date and severe penalties if the landlord breaks it. You can have your hotel, meals, and incidental expenses paid in advance, plus a generous extra payment for going along with it and suffering the inconvenience of not being at home. The landlord can be responsible for any theft or damage and return your place in very clean condition with the furniture put back in their place. You can limit the number of showings to some maximum number per week and get paid a generous amount for not being around, not interfering with the showing, and making your place neat and clean. If the broker has a brain, he will broker that deal. However, many brokers and their agents are just stupid bullies. I bought a 2-story house from a realtor. I got 1 story before escrow closed, but a different story afterwards. I used to sell real estate before I became a lawyer, so I have that inside scoop. Agents may try to bully you into doing things, or tell you that you have to do certain things, or that they can do anything they want. They can be pretty nasty. The broker himself may chime in if you present the problem to him, and tell you even harsher terms what the agent said. That's when you put your foot down. You tell the landlord that you want it stopped. He can do it, but he probably will be just as arrogant and threatening as the agents were. You gave him his chance, and he blew it. Okay? You can sue the landlord, the real estate broker and agents, the workmen, and anyone else who trespassed, using small claims court to sue for up to $12,500 in each of separate lawsuits. You can change the locks as a protective measure. You tell anyone who comes to see the property that you're in a dispute with your landlord, and if they're stupid enough to buy the place, you will have to name them as defendants in your lawsuit. You tell them that their agent probably never told them about all the problems with this property because he doesn't care and just wants his commission. You tell them they're better off buying another place and hiring a different agent who deserves their trust. That will put an end to the sale of the property. No agent will show it. If the landlord complains, you remind him that his broker mishandled the situation and should be sued for malpractice. If the landlord threatens eviction, you put in writing that you are enforcing your rights under Civil Code 1954 and that he is retaliating for your doing so. As a practical matter, the whole reason that the landlord was making the repairs or improvements and showing the property was to sell to somebody who wants you evicted as a condition of the sale. Your days were numbered, irrespective of your abandoning your rights. If it comes to an eviction case, you have already laid the groundwork to win. The notice comes to terminate your tenancy, you warn the landlord and his lawyer that this is malicious prosecution, and you fight it out. 4 months, paying no rent. The landlord may lose the property in foreclosure rather than be reasonable in respecting your rights. You tell them to leave, and when they don't, they have committed the crime of trespass. I mentioned earlier that the trespass by someone other than the owner is a criminal offense. You have the right to make a citizen's arrest, like security guards do. Penal Code 834 and 837 permit that citizen's arrest. Penal Code 839 permits the arresting person to get help from others to do it. You are also permitted to use a reasonable amount of force to subdue the resisting criminal suspect. Under Penal Code 841, you only need to tell the person that you are making a citizen's arrest of them for trespass. You don't need to read them their rights. When finished and the criminal suspect is tied up, you bring him to the police or sheriff for them to take over. You have no criminal or civil liability if you follow those simple rules. Of course, that's hardball, but you need to know that you can do it if it comes to that. If the landlord retaliates by threatening eviction because you did that, his eviction is illegal as well. We've covered a lot here, but you need to know that you have control, not your landlord, and that you can take effective action. This is not the whole story, and the details can make a difference. It is as much as I can tell you in general. You probably want to watch other videos on my site covering similar and different topics that may apply to you, including suing your landlord. Bullies are cowards. That's why they're bullies. Tell your neighbors about this as well, and about my CalTenantLaw.com website. Knowledge is power.